Welcome back to Orange Hat Reviews. Hope you're all having a wonderful day. So, I reported on the Steve Ditko estate going after Marvel for termination of copyright against Marvel for Spider-Man and Doctor Strange. Well, this story has progressed, and it seems that a lot more families of creators, bikes going by, sorry, seems that families of creators have come forward, and Marvel's not having any of it. They have actually filed countersuit. So let's get into this by bounding into comics. Marvel strikes back, countersues to keep rights to multiple characters, including Avengers and Spider-Man. Thank you to Bounding and Spencer Piculi for this for this article. Just one day after it was made aware of efforts by the estate of Steve Ditko to terminate their copyright claims to Spider-Man and Doctor Strange, Marvel has countersued both the Ditko estate and a number of creators who have filed similar lawsuits in an attempt by the publisher to retain their exclusive rights to an extensive number of their iconic characters, including the aforementioned two heroes and multiple Avengers members. So, as first reported by The Hollywood Reporter, who claimed to have viewed but did not make public the freshly filed complaints made by attorney Dan Petrocelli on Marvel's behalf, the once renowned member of the comic book Big Two is seeking declaratory relief that these blockbuster characters are ineligible for copyright termination as works made for hire. It's a legal definition whose provisions would render the publisher as the sole owner of the characters. Basically saying that all these families whose members created these characters while working for Marvel owns those characters because they were created while these people worked for them and were made for Marvel. So Marvel is basically playing a very dirty game. But can you really expect that, or can you really expect any less when the mouse owns Marvel? So let's continue. In their legal filing against Iron Man, Thor, Ant-Man co-creator Larry Lieber, the only one provided by THR, The Hollywood Reporter, Marvel can be seen arguing that since they assigned Lieber stories to write, had right to exercise creative control over Lieber's contributions, and paid Lieber a per-page rate for his contributions. Any contribution made under their instance and expense renders all respective contributions by a given creator as work made for hire, thus rendering copyright termination laws inapplicable. Which could spell a lot of trouble. The publisher further asserts that these cases bear more than passing similarity to a previous attempt made by the estate of legendary creator Jack Kirby to terminate Marvel's copyrights over his various co-creations, including Fantastic Four, The Hulk, Spider-Man, Thor, and X-Men, which in 2013 the Second Court of Appeals determined held no water since Kirby had created the characters as a work made for hire. According to United States copyright laws, the United States Copyright Act of 1976, work made for hire is defined as a work prepared by an employee within the scope of his or her employment, or a work specially ordered or commissioned for use of a contribution to a collective work, meaning characters that come together with other characters and other bigger projects, as part of a motion picture or otherwise audiovisual work, as a translation, as a supplementary work, as a compilation, as an instrumental text, as a test as answer material for a test, or as an atlas if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. Furthermore, the U.S. Copyright Office adds that termination provisions are intended to protect authors and their heirs against unremunerative agreements by giving them an opportunity to share in the later economic success of their works by allowing authors and or their heirs during particular periods of time long after the original grant to regain the previously granted copyright or copyright rights. These creators who've previously filed copyright termination notices and now find themselves in sights of Marvel's legal teams, as well as their respective creations, include Lawrence Lieber, co-creator of Iron Man, Thor, and Ant-Man; Patrick Ditko, the brother of Spider-Man and Doctor Strange, co-creator Steve Ditko, and current manager of his estate; Michelle Hart Rico and Buzz Donato Rico III, the family of the Black Widow co-creator Don Rico; Nancy Solo and Eric Colan, the family of Falcon co-creator Gene Colan; and Keith A. Detweiler, a current executor of the estate of Don Heck, who co-created Iron Man, Black Widow, Hawkeye, and Wonder Man. If unsuccessful in their efforts to define the contributions of the above creators as works for hire, Marvel would inevitably be forced to share some of the profits derived from said characters with the respective creators if they wish to continue using most of their first-string lineup of heroes. However, if Marvel is to succeed, it would both be setting a worrying precedent for copyright termination law, but also provide Disney with further ammunition to use in their continuing fight against the advancement of their characters in the public, or into the public domain. So, honestly, my thoughts on this is the mouse is playing dirty. They're playing greedy. They don't want to lose their cash cows. And they don't want to share with the people who created these characters, who put their hard work over the many years to bring these characters onto the page and onto the screen and into everybody's hearts. It is much like the whole failing to pay royalties to people like the Star Wars authors who have not received royalties for their work that came under Disney's purview when Disney bought out Star Wars. Disney does not like to pay people what they are owed, and it is a very selfish and very greedy way of life. Unfortunately, that is one of the darker aspects of capitalism. You can actually make all that money, and it takes a legal filing in order to rouse the rights of people to be paid what is owed to them. And I'm not saying that capitalism is a bad thing. I am simply saying that capitalism has its dark sides and light sides, much like Star Wars. But as for the families to these respective characters, I do believe that they should have a right to terminate copyright if they want. I do not believe that Marvel should be the ones to keep it all simply because it was made or those characters were created for them. The creators and their families had a right to share in the wealth that was basically generated by their contributions. I think a fair share should be given. But Marvel and Disney don't want to do that. Anyway, folks, that is going to be the video. You all know the drill. Like, comment, subscribe, share, all that jazz. Let me know your thoughts down in the comment section below. What do you think of this story by Bounding into Comics and what's going on in this world? Do you think that the creators and their family should have a fair share and also have the main rights, or do you think that Marvel should keep them and Marvel should also have exclusivity? Let me know all your thoughts down in the comment section below. This has been Orange Hat Reviews. Stay humble.